Hey, it's James, Father's Rights and Resources, hashtag how I got custody. Let me tell you in this video what you can do. I'm going to try and be positive and encouraging in this video. You can go to family court and learn everything that you need to, if you have a family court case, restraining order case, domestic violence restraining order, child support. You can learn everything that you need to know, or everything that a lawyer supposedly knows, because everything that they learn in law school is online and available for you. But you don't need to know 3 years worth of law school BS, because a lot of times they talk about theories and all this other stuff. The practical stuff that you need to know is available to you. Here's another thing you can do. You can know your case 100 times better than an attorney can. Why is that? Because it's your life. I actually won my contempt hearing, my first contempt. I got my baby's mom found in contempt for contempt that she committed within the first month of our first court order. So right away. Now, I had a hearing soon after she committed it, but she said she said an unnecessary surgery for my daughter the day of the contempt motion. Her attorney is the first attorney is such a bum. And I won that hearing, I believe, in the middle of oral argument. I caught her attorney off guard because I remember I had all the exhibits I needed available. I had like 35 exhibits. I only used 2 of them in the hearing. That's why I do the analogy. You go off to war, you want to have every weapon available. You will not use every single weapon in the battlefield probably, but you want them all available in case you have to use hand-to-hand combat. You got a grenade, you got a bazooka, you got this or that. You got everything to cover every scenario. So I did my argument, they did a response, and I'm like, oh my gosh, I have this exhibit, and I have that exhibit. Your Honor, the mother said this back in this day, and here's a picture of a calendar when she withheld the child before I had a court order. She's withheld the child after I have a court order. What are we doing with court orders if they don't matter? If we write stuff down, the reason we write stuff up and write it down so everybody's on the same page. I finally got a court order and she's still. And then I had an excerpt of a transcript. I said on the record, she said she's not trying to withhold the child from me. She withholds the child for 40 days around the time she said that. I get a court order and they're saying she wants me to see the child, but I'm still not seeing the child. And the attorney, I can see him out of the corner of his eye. He's flustering and fumbling around looking for the exhibits I'm talking about because I didn't mark his. I tabbed the judges. It was a family law commissioner. I tabbed the commissioner's page. I tabbed mine. I didn't tab his. And he's flipping through and trying to find the stuff. One time I served her later attorney. I served him with stuff shuffled out of order. And then I actually stapled everything like 40 times. So he had to get a bunch of staples out to even open the stuff up and look at it. That was kind of fun. But I won because I thought on the fly. I remembered something that happened from our previous court hearing and something specifically that she said, because this stuff was emblazoned. You know and remember details about your case that no lawyer can remember because it's your life. You don't have to memorize your life. You're living it. So you can do better at oral argument than your attorney because you can remember stuff and remember stuff on the record and remember somewhere in this one declaration she said about the second page. Let me turn to it because you got it handy. And if you do a consult with me, you know how to have your stuff all handy. Every one of you should have a record of your docket, because if you have a court that has the dockets numbered, like in Washington or in King County specifically, where Seattle is, when you go to the docket, it has a column that says sub number. So it's basically an index number. Number 1, the summons. Number 2, petition for divorce. Number 3, motion for this. Number 4, declaration of that. So if you have a docket with numbering, you have that docket with you at all times when you go to court. And then you have everything in a 3-ring binder of your file with the stuff tabbed, and you remember something, and you say, oh, Your Honor, let's say you have a contempt motion from the court. You don't have every single exhibit of every single document that she did, You remember, oh, I remember when she said that one declaration. And you look like, okay, where's the declaration from back in April? Okay, it's sub number 17. Your Honor, if you take judicial notice of sub number 17, page 4, she said this at that time. Now she's saying this. She's lying to you. See, you'll remember stuff. Now, you may not remember exactly where it is, but if you're organized and you have stuff ready to go, then you can throw this stuff out. You know, see, I do videos like this and I talk about details and stuff like, oh man, this is great information. And everybody ignores me all the other times or doesn't get a consult because they see me chewing guys out to grow some balls and get on the offensive and be a man and be a warrior for your kid. So they get afraid to get a consult. When you should know, if I won in court over and over without an attorney, that should be enough to get you to want to get to a consult with me. There's information like this right now is stuff I go into detail with people in one-on-one consultations. You should want more and more of this stuff. Now, you can figure all this stuff out on your own completely like I did. I had a little bit of help from a father's rights advocate from Dads Against Discrimination. The biggest help I got is when one of my first meetings with him, he's like, here's the book. He had a big old book. Here's the book on the local civil rules of procedure. Here's King County Local Civil Rule 7. It says you organize your motion like this, and here you go. Write that down. Or take a picture of it. That's all he gave me. And we chatted about different things and stuff. That's all he gave me. Everything else I pretty much learned on my own, except for, you know, getting on the offensive and thinking about doing a couple things here and there. The guy helped me out a little bit to get me going, and I knew where to go look up the rules. So then I had to go look the stuff up myself and all that other stuff. All that being said, you can remember stuff because you don't have to remember it. Your attorney has to remember it. You already know it. It's your life. You can go to court anytime that you want, and you don't have to wait for a call from the attorney or let me call the attorney and see if they're available, see if they want to do the strategy. You want to do a contempt motion? Boom, go file it. You're not tied down by the attorney. Oh, that's politically incorrect. Oh, that'll look bad. Oh, this and that. And you got to argue with your attorney. Then they bill you for talking to them on the phone, arguing with them about a strategy they don't want to follow. The insanity is crazy with using an attorney. If you can speak English, even if you can't, you can get a translator. There's really no excuse for this stuff. You can tell your story about your life better than anybody else. All the laws, all the case law, all the rules, all the court forms, for the most part, are online. And if they don't have a court form, I have packets in my store that are mostly $45 that are worth hundreds or thousands of dollars with arguments your attorneys would never think of. Arguments that have worked for me and countless other fathers and mothers. You can put on your own trial. I've had guys who were, I was a warehouse worker flunked out of college when I had custody of my daughter. I went back to school later and got a bachelor's in law and justice from Central Washington University. I don't really care about that. I just did it just for fun. I barely had to study because I already knew this stuff. You care about your kids. No one in the world gives a shit about your kids, including the narcissistic parent, the judge, the guardian ad litem. These are all agents of the government that see a million kids. Your kid is just a face, just a number. It's not a human being to them. They don't care. You have the time, energy, and devotion to be able to deal with this stuff. If you got a lawyer, you're already doing half the work anyway. Gathering declarations from friends, digging up evidence, digging up all your financials and organize them. Some attorneys let you do a little bit more work to save money. You're practically the attorney's paralegal. You can do this stuff. I have a guy who did a 3-day trial who's a construction worker who had an alcohol or drug issue. Put on a trial and destroyed the mother and got full custody. I have another dad. He had every other weekend. They were trying to take that away and make him pay $20,000 worth of attorney fees. He was content with the every other weekend, and he wasn't trying to fight too hard, but he did a 4-day trial. He was a painter at Boeing. The only reading he liked to do is read the Sunday paper, and that's about it. He'd go to work, do a blue-collar job, sit at his place by the lake, work on his boat or stuff like that. He faced a married couple attorney team, and they did not get attorney fees. The mother had to pay her own, and he maintained the visitation that he wanted. They didn't get away with winning, and he schooled the first attorney quit because he schooled them. You can do all this stuff. It's best to get help from me to help you.